want to present, the way you want me to present myself is the same way you should come. If I came in shade to attend to you, would you be okay with it? Should we try it? So it has set us up some little order. These people are more then we can do other things outside. What I'm saying is that for us to start litigation of this case, we must stop them. And amendments are not even the fact, they are addition of persons. You're not adding charges, you're adding persons, which will lead us backward. So you can charge this person on a different charge sheet and still the end of justice shall be made. So it does not stop the justice from being made just because of stopped an addition of persons. You can open a new charge sheet and have that person prosecute. But for now, I also cannot come here every single day on disclosure and amendment. And so today, the 27th of this month, February, we shall stop additions and amendments. We are going to start with these people and we'll see where they are ending. And I hope we do not go back to the same. So we can proceed with the business for today. Or what? Let me have the court delegated chair for council. Court orderly, help us with the chair for council. Let me have the court delegated chair.
This honorable court to regulate the media. Your Honor, the reasons were given. We submitted on the same and shared authorities, Your Honor. The defense, however, sought court's leave to make a response, to prepare and respond to the prosecution's implication. Your Honor, that is what the court done for.
Yes, Your Worship, for the record, I'm Mukkooti. However, Your Worship, before I proceed to give my response to the constitution application, as an officer of court, it is prudent that we guide court on how we proceed. On the 23rd of January, 2026, when I appeared in court, there are only 10 judges people, upon which this application was made. A21 who has just been added should not be involved in this application because he was not an accused person like that. Because I don't know what he feels of. I want court's guidance. Then I can proceed.
This is the reply from. I am just doing.
It's okay, Your Worship. I understand.
He's an accused person and he's here, and I'm saying we're ready to give the charges.
Not surprised, Your Worship. But I wanted him to be.
I cannot exempt him from this file at this point.
I've understood that. I wanted him to know why you are making this reply. Because you are not
And it will affect him either even if the court gives the ruling, it will affect him. So it is not. I cannot isolate him at this point.
Yeah, most obliged, Your Worship, but I wanted him to understand why we are making this look like. But you can proceed.
Is he represented?
Yes, Your Worship. Is
Thank you.
represented. Your Worship, the state made an application, and mainly he was concerned with the breach of the subsidies rules, as well as the security of the persons involved in this matter, including the witnesses, which we seek to reply to today. Your Honor, the law of subsidies is clear. And I believe my colleagues and the defense team, as well as the prosecutor also, we understand that matters before court should not be discussed, or opinions given on their merits or demerits. Your Honor, from the start of this trial, neither of us, the lawyers and the defense, I'm not sure whether the prosecution has, but neither of us or the defense team discussed the merits or even the demerits of this matter anywhere, either in this court because they have not started trial, or even in the public. The prosecution did not even adduce any form of evidence relating to the alleged subsidies. And for us, we can confirm because we know the effect of subsidies in discussing matters. As advocates, we cannot do that. And we are not even about to do it. In his application, Your Worship, the state submitted that the media was doing live coverage in this matter, and he alleges that that was also part of the subsidies, breach of the subsidies. But I want to clarify this, Your Honor. On several occasions, the prosecutor and this honorable court have been clear that this matter before court, before these accused people, is a matter of the public interest. Your Worship, we also know that it is a matter of public interest. And considering the size of our courtroom and the number of the accused people before you, the courtroom space is small, as you can identify. Most of the people are standing. And also, considering the restrictions from the main road towards accessing this court, at some point it even affected us, the lawyers, but it was rectified. But it still affects the court users, the relatives of the accused people, and the sureties. Your Worship, the media only does coverage on this matter because not every relative of these accused or their sureties can access court. And some of the accused people, including A8, are leaders of the second biggest political party here in Uganda. So they have a lot of following and supporters. Whereas some of his colleagues are also in prison, by covering these proceedings by our media group, it is clearly by the media group here, helps also those leaders that are still incarcerated to follow for proceedings. And many of these details have already been in the public domain since August. So my submission on the subjudice is that the prosecution has not made any evidence or even pointed out any media group or personnel that has commented on this matter in a breach of the subjudice. The second issue, Your Honor, is about the security of persons involved in this matter. Your Honor, the prosecution alleges that the parties involved in this matter, including the witnesses, are facing a security risk because of the media coverage of this proceeding. But I've always appeared in court, and the record can clearly show that the state has always admitted not having concluded investigations in this matter. And therefore, they have not fully disclosed to us the defense. So, neither the court record nor the defense counsel, or even the accused people themselves, nor the witnesses that are intended to be relied on. And you remember, Your Worship, on the 23rd, I even raised an issue about the complainant in this matter. We don't know. So there's no threat on the security where we don't know the people that are threatened. And two, there's no evidence that was adduced by the prosecution regarding any threat. And if there was a threat, a prosecution is in a better position complain and bring the people threatening them to this honorable court, because I know that is an offense. But in the absence of any of the facts in that regard, I find that the prosecution's allegations are far-fetched and should be ignored by this court. Your Worship, the state is actually in a better position to provide the security for its witnesses that are not yet known, and for us as defense counsel. Because Your Worship, we the defense counsel might threaten because we are representing the legal system. By the security itself. And Your Worship, for the record, I'm a victim of that threat. Because I was bundled.
Your Honor, I wish to object to this kind of. Your Honor, no.
We are here. I have a police reference to this. I have a police.
And it is because you are a suspect in another case. So, Your Honor, let's watch business. We object to the way my landed brother is conducting court business. We are here for the response to this application.
Yes, Your Worship, I was giving you a threat that I faced and the condemnation is that because I'm representing this people. I have a police bond to that.
We vehemently object. This application was to regulate the media covering these proceedings, not to ban them. Now, for my learned brother, it is ludicrous that he is going into things that are unrelated.
And that's why I'm going to cancel. Stick to this.
That's most obliged.
The prayers made by state.
Most obliged. Yes, because I'm still on the security of the person involved in this matter.
Unless you're saying you enact the state that we are all under pressure.
No. Yoshi, I'm saying that the state has capacity to provide.
Because it seems like you're saying that
No. I'm saying the state has the capacity to provide security to its witnesses. And us, if at all the state. But let me proceed on. As I earlier said, the witnesses are not yet known to court, and no witness has ever been presented. So, it is not correct for the state to say that there are no witnesses accredited as well, and that the court should be disregarded. Your Honor, I'm going to go to the decision of Justice Lady Mugambe in Uganda Court Reporters Association Limited versus the Attorney General. Civil Division, miscellaneous cause number 87 of 2014. And it was for judicial review. Your Worship, the brief background is that the chief magistrate at Uganda Road had blocked trial in a camera of some accused persons who are allegedly under a high-profile case involving police officers. And upon that decision, the association made a review application for Justice Mugambe. And in Justice Mugambe's ruling, she had this to state while overturning the decision of that magistrate. I've given the court a copy. And Your Honor, in that ruling, the land judge said that the state cannot simply invoke national security to block media. That the state cannot simply invoke national security to block media. It must provide concrete evidence. It must provide concrete evidence about the same with politicized security. That it is not enough to raise state security without more. Some continuation. It is for the court to determine whether a matter falls. It is for the court to determine whether a matter falls within the exception of Article 41. That is Article 41, access information only. And to do this, the state must produce evidence upon which the court can act. Worship, this was also referred to in the case of Major General David Nyefuza versus the Attorney General. Constitutional Petition number 1 of 1996, which was referred to by my colleague in his application. So, Your Worship, where the state has not provided any factual evidence regarding the security of the persons involved in the matter, the court should just ignore that as a mere allegation. And disregard this application. Worship, in the same decision, Justice Mugambi also emphasized the matter or the importance of an open justice principle. Worship, in that decision, Justice Mugambi emphasized that the open court principle is the fundamental pillar of a fair trial. The open court principle is a fundamental pillar of a fair trial, and that any limitation must be justifiable. That any limitation must be justifiable in a free, fair, and democratic society, as under Article 28, 41, and 43 of the Constitution. Your Worship, court also looked at the compelling rights, and that is page 11 as well, paragraph 34. In this case, the different judges discussed through the importance of open justice, through hearing in open court, and the role of media, access to legal proceedings, as well as the process to be adopted in such applications, for when it is to be banned. And they referred to Justice Masenke DCJ at page 39 in the Major General Bill of the Yakuza versus Yakuza, where they ran DCJ by then, as then was explained, that although the right to open justice is not absolute, in each case where derogation is sought, the court will have to weigh the competing rights. The court will have to weigh the competing rights or interests carefully with a view to ensuing that the limitation places on open justice is properly tailored and proportionate to the end it seeks to attain. Your Worship, the same decision emphasizes that open justice system is an integral part of the constitutional vision of an open and democratic society. I worship, as I'm about to conclude on this, on page 12 of the Uganda Journalists, Uganda Court Reporters Association, page 12, and that is specifically paragraph 37. The Land Judge referred to the case of Bifo, son of Mandile, versus where it was held that justice should be done openly, save in special circumstances for which statutory provision to the contrary is made, and save in certain other very unusual circumstances it is better that a man should not be brought to justice at all than that justice should be done to him without the public being given the opportunity of seeing it done. Worship, it's utmost important that this honorable court be pleased continue allowing the media and journalists conduct live covering of the proceedings which would leave out any bias of bad reporting or misinformation regarding this matter. Because the media are seen as the eyes and the ears of the general public and any interested party who are unable to attend court. Therefore, Your Worship, the media only acts. The media only acts as a surrogate. The media acts as a surrogate for the public in ensuring accountability within the justice system. Then I would invite my colleague to proceed.
Your Honor, my name is Mufumbiro. Your Honor, in addition to the submissions made by my colleague, I wish to add on that prosecution's application to ban the media from live coverage and reporting of the matter before you. Has been brought with unfairness or in bad faith. Your Honor, I'll refer you to Article 41 of the Constitution. Right of access to information. Your Honor, if court permits, I will reproduce the law. Every citizen has a right to access information in the possession of the state or any other organ or agents of the state, except where the release of the information is likely to prejudice the security or sovereignty of the state or interference with the right to the policy or any other person. Your Honor, as my colleague submitted, the accused persons comply with one of the popular political organizations called the Mutwe, for which they have supporters and followers. When court bars media from covering or having live coverage in this matter, this will be a deliberate denial by the state for the followers of the accused persons to access information related to the matter before you. Your Honor, the law goes ahead and says, except where the release of information is likely to prejudice